Well, I just want to go over the guidelines. This is not an interview. I'm sorry, this is an interview, not a debate. Follow-up questions are allowed, are not allowed unless for clarity. Each candidate will not answer each question. Candidates are allowed 1.5 minutes to introduce themselves. Panel members are allowed 30 seconds to pose a question. Well, I guess it doesn't really apply here, but candidates are not allowed to, I'm sorry, candidates are allowed 1 minute to answer. Panel members are allowed 1 question. The question may be to one candidate, or the same question can be posed to all candidates. And again, we only have 1 here, so I guess that's not going to have to worry about that. This is not a forum to air personal grievances. Panel members, please keep your questions generic. And candidates, do not mention the other candidate in your response. So, I guess now is the time for you to introduce yourself.
Thank you. My name is Maskall, and I'm a candidate for Family Court Judge in Department T. I have been a practicing lawyer since 1990. I graduated from California Western School in San Diego. I first began my legal career in Washington, D.C., doing telecommunications law and intellectual property. I then moved here to Las Vegas because I was offered a position with a family court judge, and little did I know how much family court was going to affect my life. I think that being a family court practitioner has shown me compassion and sympathy for individuals, good people going through tough times. I have done a tremendous amount of pro bono work throughout my years here in Clark County. I moved here in 1997, and in 1998 I won the Pro Bono Rising Star Award. Since then I've won numerous awards through the Pro Bono project, including Attorney of the Year, and our firm has won the Firm of the Year for mid-sized firms. I have decided to run for family court because I have a passion for protecting children and ensuring that the best interests of children are upheld, and making certain that the rights of parents are preserved to the extent possible. So long as a parent isn't a harm to a child, I think that parents have the duty and the right to be with their children for as long as they possibly, well, for the minority of the child's life. So that's part of the reason why I'm here today, and I'm asking for your support, and I thank all the panel members for coming out today.
Thank you very much, Judge.
Thank you.
Can I have the first question?
You want to start out with this session?
Oh, sorry. I'm sorry, with the far end. I'm sorry, I can't read the name.
Jameson Ahern,
It's right here.
United States Marine Corps. Can you hear me now?
Can you hear me now?
I can.
Oh, yeah.
Excellent, good morning. Question I have for you is, what would you do differently that you believe is not being done properly in the family court system? And be specific as to how it would apply to veterans and their families.
That's a good question. What would I do differently? I think that families in general, if you can get mothers and fathers to work together, you're probably going to wind up having a better result for the child. No child wants to be in the middle of any kind of turmoil between their parents. So if there was a way of mediating and having mediators take a look at situations before they reach the family court, which we have mediation, but it's only for the issues concerning children. But specifically for veterans, I'm thinking that I know SB 271 was an issue recently, and I think that guidelines like SB 271 would be good for veterans.
Good morning.
Good morning.
Thank you for coming. I'd like to understand a little bit about how you think legally, as opposed to just specifically
Okay.
for family court. I'd like you to talk about a Supreme Court decision that you agree with or disagree with, so that I can see a little bit into how you think constitutional.
You know what, I recently had interviews where they asked me about Supreme Court cases, so I did look them up afterwards. DC versus Heller, where the Second Amendment was extended to individuals' rights. I believe that was a very good court case. And Hamdi versus Rusfield, I think, or Rosfeld. I can't. Hamdi is the first name. It's a case from 2004 when the Supreme Court said that individuals, including United States citizens, could be held without habeas corpus. I believe that that was a very bad case.
Rumsfeld,
Rumsfeld? Thank you.
Secretary of Defense.
At what point do you believe a child's opinion should enter into a case, in a custody case, I should say, as to what parent it should be with?
So long as the child is capable of forming an opinion, and so long as that opinion hasn't been swayed by one parent or the other, I think that children should have a say pretty much at all ages. Obviously a 5-year-old is going to say that they like the parent that they've been with last just because they like, I think that children want to love both sides, and whichever parent they've been with last is the parent that they probably would refer to more than any other parent, but it doesn't necessarily mean that they don't like the other parent at all. So I think probably in a family court right now, they say around age 12 or 13, I think that you see 9-year-olds who have a very specific idea of who they want to be with, and if that 9-year-old is clear enough and coherent enough to formulate an answer or response, I think that they should be given the opportunity to do so.
Good morning, Michael Mazur. I have a hypothetical question. How would you rule if you either have a pro per or an attorney that's not following the Nevada rules of civil procedure as far as deadlines for filing replies or oppositions? How would you treat that? Would you be stringent on them? Would you allow them second chances, like a court of equity? Just want to get your input on that.
Well, I came from Washington, D.C., where if you didn't follow the rules and you didn't file something timely, that particular pleading was out the door. I don't know that you can do that in family court where a child's life is at stake. So I do believe that that those particular rules have to be a bit more lax. I don't anticipate that pro per litigants who come into the courthouse are going to know the rules of civil procedure the way that attorneys do. However, you're correct. A lot of attorneys pay no attention to the rules of the court, and I do believe that they need to be reminded of the rules because it only leads to fairness in the end. If someone does a motion and an opposition is due 10 days later, if you get the opposition 3 days before court, it's very difficult for the moving party to reply to that. But for the best interest of the children, I do believe that all cases should be decided on the merits.
Domestic violence has been rising, as well as murder-suicide following custody orders. We've seen that in most cases, the protective parent had asked for temporary restraining orders, which were repeatedly denied. What would you implement, or how would you view these situations?
In high conflict cases like that, currently we have hearing masters who hear temporary protective order cases, and I really do believe, and I'm sorry, I need to finish. They hear all temporary protective order cases unless somebody specifically requests that that particular case be heard before a judge. I would want to hear all of those cases myself. I think that it leads to continuity, and I think that it leads to better decisions when things like that arise. I also believe that the DA's office needs to be more involved in letting the family court know exactly what's going on in the criminal side of domestic violence situations. Because the family court often doesn't even know that a case has been filed unless someone brings it up.
This almost sounds like a follow-on to the previous question, but as I understand, the default situation is that a child is with the parent. A child who has been abused, going back to that parent is dangerous for the child. And in spite of how would you respond to the push to keep the families together?
I'm not sure that I understand. You're saying that a child who has been abused has been given back to the abuser?
Yes.
Okay, well, I mean, the court's there to protect the children. The mandate of family court is to make sure that we uphold the best interest of the children. It's certainly not in their best interest to go back to an abuser. So I would not allow a child to go back to an abuser in any situation.
Okay, first off, I want to thank you for actually showing up. For whatever reason, the incumbent didn't think this was an important enough event for her to show up. 1 out of 6 registered voters in the state of Nevada are registered veterans. So what specifically will you do that your opponent has not done to be helpful to veterans?
Well, if a veteran enters my courtroom and has no legal representation, I'll make every effort to ensure that the veteran is afforded legal representation, whether that be through the pro bono project or any other agency that would help them. I think that, in family court, it's often sad. I mean, there's a lot of veterans that you see that basically just give up and enter court by themselves and pretty much take whatever happens or whatever the judge decides is in their best interest or in the child's best interest. But I really do think that they need representation at all levels.
Okay, so if a veteran were to come into your courtroom and decide that they had to represent themselves because they didn't have the money to hire an attorney, or they did not feel that an attorney that they tried to hire understood their issue well enough, would you or would you not, how would you perceive that individual? Would you give him the same rights as you would anyone, a non-veteran who tried to defend themselves? Or would you say that the old adage is right, someone who tries to be their own attorney has a fool for a client?
No, obviously I'm not going to treat veterans poorly. I respect veterans. I grew up, I'm an American citizen having been born here, but I was raised in Canada. And I mean, I came down here and veterans are so much a vital part of the United States' being, whether it's the economy or our freedom. I think that Canada takes advantage of the fact that we're your neighbor. And I think that United States citizens don't know how lucky they have it here, and they don't know how much they should be respecting veterans. So no, I would absolutely find out first whether the veteran truly wanted to represent themselves, and then secondly, if it's just a matter of the fact that they can't afford counsel, I can certainly refer them to the pro bono project and then make sure that they do have counsel.
Excuse me, before I go any further, I just wanted to let the folks know, we have 2 judges here in the audience. Judge Pollock. Judge Pollock, can you let us know? Oh, there. Outside. Oh, Judge Pollock's outside. Well, that's great. And Judge Herndon. Also outside? Oh, no, there he is. Thank you very much, Judge, for being here with us. And of course, Judge Ochoa, who already got interviewed. Dr. Hawkins, would you please proceed?
Are you running because you believe you're a better candidate or to address a problem in the current department? And if so, what is that problem?
The answer to both of those questions is yes. I do believe that I'm a better candidate, and I do perceive that there are issues in Department T. Those issues were addressed through a Las Vegas Review-Journal article on December 30th. I know that this isn't supposed to be bashing the other candidates, so I'll leave it at that.
I appreciate that. Judge Sott.
Thank you.
Thank you for being here. My question deals with your interpretation and the application that you would give to the Constitution. When it comes to interpreting the Constitution, what is your judicial philosophy with regard to interpreting the parts of the Constitution that are maybe not so very specific?
Well, any parts that are not specific, I would turn to case law and see how the case law has been interpreted. I believe that the Constitution has to be upheld, and that part of the oath of taking office is to uphold the Constitution of the United States, that of Nevada, and the laws of the state of Nevada and the United States. And that's what I would strive to do at every turn.
I got just one quick follow-up question. Is this the first time you've run for office?
No, it is not.
Okay, thanks.
Thank you. And I wanted to thank all of you for the opportunity to speak before you today. Thank you.